All right. Good morning, all. Welcome. It's a pleasure to see all of you, and we have a full house and a big agenda. So I am going to get started on some roll calls, some meeting minutes, and then we have a special guest with us, Representative Meg Froelich, who is one of the sponsors of this task force. And I want to introduce you to all of her in just a moment. So again, welcome, and I will start to call out. If you will just let me know that you're here, that would be fantastic. So I'm going to start with Dawn Alexander. Okay, Yolanda.
Morning, everyone. I'm here.
Good morning, Yolanda. Thank you. Kevin Bishop.
Morning, I'm here.
Excellent, Kevin. Ashley Chase.
I'm here.
Hello, ma'am. Jill Cohen.
Good morning.
Hi, Jill. Welcome again. Jessica Dotter.
Morning.
I know you're here. You're like prime and center to speak today. Michelle, I saw you.
Yeah.
Yes, ma'am. Hello. Tara. Do I see her anywhere? Not on the screen yet. Ida. Not yet. Leanna, I know I saw you.
I'm here. Good morning.
Yes. Good morning. Zane.
Good morning.
Hi, Zane. Adriana.
Good morning.
Good morning. Lori Jenkins. Not here yet. Gina Lopez.
Hi, good morning, everyone.
Hi, Gina. Chris Menz.
Good morning.
Hi, Chris. Michelle Murphy. Not here yet. Let's see. Sarah. I thought I saw Sarah. Sarah, I know I saw you earlier. All right. We're coming back to that. Rashawn. I see Rashawn's window up. So hello. Nikki. Kathy Wells, our co-chair.
Good morning, everyone.
Morning, Kathy. Donna Wilson.
Good morning.
Hello. Margaret.
I'm here. I'm sorry I couldn't get off mute.
And you have done so successfully. So good morning. Good to see you. Margaret.
Hey, good to see everybody.
To see you. Carlos Castillo. Not here yet.
Good morning. I'm here.
Oh, you are here. Good morning. Let's see. Tara. Did I already see Tara? I think I did. Okay. Jennifer Isle.
Hello, good morning.
Hi. Nate Halpern. Shayna Coran.
I'm here.
Hello. Tess. And Colleen.
Good morning, I'm here.
Hi, Colleen. Thank you, as always. Jade.
Good morning, I'm here.
Hi, Jade. And Kelsey.
Good morning, I'm here.
Hi, Kelsey. All right. Is there anybody who is a member of the task force that I did not call?
This is Sarah. My Zoom quit on me, so you might have said my name when I was trying to figure that out, but I'm still trying to figure that out, but I'm here.
Thanks, Sarah. I knew I saw you. I knew it. All right.
This is Lori, and I'm here as well.
Oh, good. Thank you, Lori. We'll mark you down. Excellent. All right. Well, good morning, all. And again, just moving through our business. All of you should be in receipt of the email that Trace sent out that contains the materials for today's meeting. I want to go ahead and begin with the minutes from the September 20th, 23 meeting minutes, and ask if there are any additions or edits or any sort of corrections that you would like to offer to those meeting minutes before we move for approval. Okay, I see no hands up. I see some head shakes no. All right. Not seeing that there need to be any corrections. If I could please have a motion and a second and announce your name as you make those motions, please.
This is Gina. I'll motion.
This is Chris. I second.
Great. Is there anybody opposed to the passage of the meeting minutes from September 20th of 2023? All right, not seeing any, those meeting minutes will pass. Moving on to what we're calling the meeting recap or meeting summary document. Again, same question. Are there any edits or corrections, changes that members would like to see to that document?
My name is spelled incorrectly in that document.
Great, thank you, Nikki. We will take a look at that. Any other? Oops. Any other changes to that document?
Oh, sorry. I'm not on mute.
Okay, thanks, Carlos. All right.
Wait. My name is also spelled incorrectly. There's no H.
Okay, thank you. I saw that on the last page, a couple members' names when we have the appendix and the membership who attended. So I will make sure to go through that with Trace just to triple check against our membership list. But thank you for that, and my apologies for spelling names incorrectly. Okay, seeing nothing else, excuse me, if we could again have a motion and a second and announce your name as you make that motion to pass that meeting recap.
Sorry, this is Kelsey. I didn't see my name on the list.
Okay, thanks, Kelsey. We will add it.
Thank you.
All right, a motion and a second, please.
This is Michelle Dossie. I'll motion.
Thanks, Michelle.
This is Ashley Chase. I'll second.
Thank you, ma'am. All right. Is there anybody who is opposed to the passage of that meeting recap from September 20th of 2023? All right, not seeing any. We will go ahead and that document will pass. Trace, I would just have Keystone note that there are a couple members who are abstaining due to their absences at that meeting. And if we can just note that in the chat.
Sure, we'll track that. Thanks, y'all.
Great. Thank you all. All right. And now on to a little bit more, excuse me, introductions. I wanted to just take a moment and introduce Representative Meg Froelich, who is here today with us. Representative Froelich was instrumental and was a sponsor of House Bill 22-1240, which is the bill that has brought all of us here together today. And I just wanted to give Rep Froelich an opportunity to say hello, and I am looking for her right now. And Rep Froelich, there she is. Yes, come on up camera and please introduce yourself and your task force.
Gosh, wow, get the power. Hi, I'm Meg Froelich. I am in my just completed my 5th year at the legislature, my going into the 2nd year of my 3rd term, and much appreciate you guys convening and taking the time. As you probably know, and like so much legislation, this originated with some terrible headlines and a case out of Children's Hospital of medical child abuse. But the more we got into it, the more we're really realizing what can be the potentially devastating effects of interacting with the child welfare system for families and for children. And so I'm very grateful for your time on this, because it is a difficult balance to make sure that we're keeping our children safe in our society, but also that we're doing what's right for families. And we're really realizing the more we look at the systems in place, that we really need to have a new perspective. And of course, Stephanie and her team were just adamant that we needed to revamp these decades-old practices. And that's kind of what your office is all about. So this is hard work, and this task force is large and necessarily so. So I'm really grateful for your time, but also interested in the outcomes. And I hope that the largeness of the task force also represents a wide swath of opinions, which will make the work even harder. But I'm really hoping that we come together and put in some meaningful systemic changes that include cultural competency and are really aware of and I was just telling the folks before the call, I've just completed a child welfare fellowship with NCSL, which the other sponsor, Representative Mary Young, had also completed the previous group of fellows. And boy, I'm on a learning curve. It isn't something from my life experience. So I'm grateful for your expertise because yeah, we're rowing in the same direction and I appreciate it.
Great. Thank you, Representative. And I just want to thank you for really being the advocate that gives us the time and the space that we have through this task force to address what you've, very accurately described as, really complex issues. So I just want to thank you. And I don't know if there's any other members of the task force that want to weigh in before we begin our agenda.
Looks like Kathy raised her hand. Oh, there we go.
Well, good morning, and thank you, Representative Froelich, for being here and for honestly, as Stephanie said, your advocacy and your hard work to give us this opportunity. This is hard work. This is complex. I'm honored to be a part of it and to be able to co-chair with Stephanie. I can just for your purpose and then for the group as well. These are. Colorado is leading in this, right? Other states are struggling with these questions and these issues. I represent a child abuse pediatric society called the Helfer Society on the National Child Abuse Coalition. There are conversations there. I just got back from Scotland, where the International Society for the Prevention of Child Abuse and Neglect conference was. And these conversations came up on the international level and really having, as Stephanie said, the time and the space to really dive a little deeper to the complexity of the tension of these issues, as you well noted, right? There's a real tension here. And as a child abuse pediatrician, I can note that tension between how do we keep kids safe? How do we support families? How do we not cause more harm? These are challenging questions. And so having this opportunity with this group, the other thing that I want to just note is that the group that has been assembled here is just fantastic in terms of really giving us a large range of perspectives on how we start to tackle some of these challenging issues. So I just want to thank you for the opportunity and for your advocacy in this space, Representative, and thanks for giving us a few moments of your busy time.
Thanks, Kathy. And Ashley, I see your hand up.
Yeah, I also just wanted to express my gratitude. I'm sort of the opposite. I'm somebody who is steeped in child welfare constantly, but it's downstream. It's once these kids are in court. And so I just really have appreciated the task force and kind of getting more upstream and being exposed to some parts of the system that we aren't as familiar with. And I particularly enjoy this group that's come together because there's a lot of players here that are not what I would call like typical child welfare folks that show up once the court case is going. And so that's been really eye-opening and educational. So I've really enjoyed the work so far. And I think we're going to be able to get to some good solutions.
Thank you. And that was definitely the theme of our sessions was, how far upstream can we go prenatal to age 3? And I'm sure you're also talking about this, but the challenges around neglect and conflating neglect with poverty and addressing poverty instead of escalating those issues of neglect into the system. So you wind up in court with Ashley. So yeah, thank you. And please, this isn't about thanking me. This is, I did one thing, which was make you guys come together. So, but as I said on the call before everyone joined, I'm waiting for you to tell me what to do. So I'm poised to act on your recommendations, and again, grateful for your time.
Great. Well, thank you. Representative. We really appreciate you being here. And for everyone's information, I'll be meeting with Representative Froelich next week, and we'll be walking through what the next steps are for 2024, what that agenda looks like. And you've mentioned one of the agenda items already, which is really looking at the definition of neglect and redefining that. That's deep work. We actually are beginning a 50-state search, and with the help of Casey Family Programs. And Crystal, I'll come to you in just a minute, but I did just want to highlight the partnership that we've had with Casey Family, as well as with our State Department and our counties here, who have all been providing data and a lot of information, so we understand exactly how this mandated reporting system works and how, frankly, it can work better. And so we will update you on all of those things, but yeah, we'll be tackling some pretty hard things in 2024. And Crystal, before we go ahead and close, go ahead.
Right. Rep. Froelich, Crystal Allen with Casey Family Programs. And I just wanted to really thank you. These are big issues that Casey Family Programs is working on hard to really look at how can we transform and narrow the front door so that families do not experience that unnecessary trauma if they don't have a safety issue. And how can we separate neglect from poverty? And this is a wonderful work group task force. So thank you very much for your work.
Great. Thanks, Crystal. All right, friends, thank you so much for just your thoughts and sharing those. And Representative Froelich, thank you again for being with us. And I believe I am turning it over to Jordan now to pick up on our agenda.
Thank you, Stephanie. Thank you again, Representative Froelich. So quickly, before we dive into the agenda we have planned today, I wanted to come online and do a little bit of a look forward for where we're heading, because if you can believe it, we are coming up on our 1-year mark. It went a lot faster than I anticipated. We have covered a lot of ground and we still have some ground to cover. So our presentation today with the who monitors the calls will conclude kind of this landscape baseline analysis that we have been doing as a group, figuring out how the intricacies of mandatory reporting and the systems that surround it interplay and work together. What we're going to be doing in November is this. Following the conclusion of this meeting, we're going to be bringing forward a syllabus for next calendar year. We have been paying very close attention to these discussions. We read the exit surveys, we pay attention to the note catchers. Everything that has come into here has helped shape what we're going to be prioritizing as we move into next year. And what we're going to be tackling in that first quarter of the calendar year will be really what was just foreshadowed by our discussions there. We will be diving into the definition of child abuse and neglect, seeing that it's foundational and how we approach the technical pieces of the directives left, as well as describing an alternative or warm line. These are themes that have come up consistently in our discussions, and for us to move into the more technical directives of the statute, we've got to lay that foundation. So what we'll be bringing forth in November, and I just want to put this on everyone's radar, and you will see it ahead of time, we have a lot left to do, and it's going to require some subcommittee work. So we'll be bringing forward the priorities for the next quarter. It'll be those two things. We will be forming subcommittees around those. So please start thinking about how you might want to exist in there, what that could look like. And then following that quarter and that work, we're going to start diving into those other very technical directives, which would include the definition of immediate, scope, can you delegate duty, all of those other 19 directives that we kind of need to get into that law and start doing that technical work. So you'll see that coming forward in November. You will get a chance to kind of preview the syllabus before we come together and discuss what that will look like. And I also just want to give everyone a very quick heads up. We're likely going to cancel the December meeting for this reason. We have our first status report due on January 1st of 2024. And we want to make sure that we take all the time we need to get that done appropriately after we meet in November, so that we can really summarize and capture the very strong work we've done in 2023, foreshadow what we're moving into based on our discussions in November, get that report to everyone here so you can preview it, provide feedback, and then submit it appropriately according to the law. So again, high level overview where we're heading. Keep an eye out for that kind of syllabus and subcommittee list that's coming forward, because our November meeting is a short meeting and we're going to have to kind of work through those points fairly quickly to make sure we get set up in a really good posture for 2024. And Stephanie, if I've forgotten anything, please feel free to add?
Yeah, I think that's the basics.
Okay, I will hand it back to you. Thank you, everyone.
All right, I'm going to jump in from here. Thanks, Jordan. All right, so a couple quick things before we get going. One, my colleague, aka Doris, reminded me that we need to take a break. So thank you, Doris, for putting the people first here. We're not taking a break right this moment, but we will take a break after this presentation and Q&A and ahead of the member panel. So just an FYI there, because it wasn't reflected in the agenda. So appreciate you reminding me of that, Doris. Second, really excited for the conversation up ahead. We, as Jordan mentioned, we're rounding out today our member panel, kind of perspectives with folks who monitor the calls. But first, we asked a couple of our members to do more of a presentation piece so that you all kind of understand on the data side, kind of where things are before we get into that panel discussion where we're kind of have an opportunity to have more of a conversation. So Jessica, daughter, and is it Adriana or Adriana? I want to make sure I'm saying it right.
Thank you. I appreciate that. It's Adriana.
Adriana. Okay, perfect. Perfect. So Jessica, we're going to start with you today. And then Adriana will go to you after. And then we'll have a short kind of Q&A just for this portion of the presentation. If you want to clarify anything or dig into any sort of data or any sort of their presentation a little bit more, we'll take a break. And then actually both of you plus our chair, Stephanie, will be coming back for a panel conversation. So then we can kind of get a little bit more into the weeds there with that conversation. Jessica, are you comfortable sharing your slides?
Yeah.
Okay, perfect. All right, you should have access to do that, and then I'll hand it over to you if you can go ahead and introduce yourself.
Well, let's see if I can do this easily. And then I'll start this. Okay.
Yep, we can see that. Perfect.
All right. So awesome to, again, be here with all of you today. I am Jessica Daughter. I'm the Sexual Assault Resource Prosecutor for the Colorado District Attorney's Council. Kind of a unique position in Colorado and honestly nationally. Essentially, I was a prosecutor for 10 years, worked primarily in sexual assault type and child abuse units, special victims units, worked in Colorado Springs for a number of years, and then in Boulder County before taking this position with CDAC. CDAC is an organization that represents all 22 elected district attorneys and essentially represents them in the sense of at the legislature with policy, provides all of the training and continuing legal education necessary for prosecutors across the state. And then in my role, I provide specific support to sexual assault, and it tends to include then child abuse and domestic violence prosecutors in ensuring that they have the training, extra support, trial resources. I'll go and actually sit as counsel in different counties on certain trials, and also just generally get to be their kind of go-to call and try to be the glue for them so that counties can talk to each other and districts can talk to each other about prosecution of these special cases. So that's a little bit about me. I live in Denver with my dog Reese. Love fly fishing and playing chess and watching movies. So I'm excited to give you kind of the prosecution perspective on this. I know as in the task force, we've been spending necessary time on a lot of the impacts of neglect. And I totally agree with some of the summaries that we've had today regarding the conflict between, neglect and poverty. I'm going to focus, of course, more on the physical child abuse and sexual abuse and mandatory reporting / failure to report aspects, because that's a perspective that I have as a prosecutor, right? I get these cases from law enforcement after they're being investigated or during their investigation regarding the actual child abuse crimes or sexual abuse crimes. And then, of course, unfortunately, sometimes have failure to report incidents that we prosecute as well. So I wanted to first kind of talk about how, obviously, my perspective is coming from criminal prosecution, representing the government. And when law enforcement then investigates and brings these crimes, it's up to the district attorneys to determine really whether we should proceed forward with charges. I think there's a myth out there that law enforcement alone makes those decisions. They make arrest decisions in the sense of public safety, but then it's up to the district attorney to determine whether there's probable cause to charge a crime. And it sits in our rules of professional conduct 3.8. Those are the ethical rules for attorneys and especially for prosecutors, that we shall refrain from prosecuting a charge that a prosecutor knows is not supported by probable cause. So that's, of course, not only on the child abuse, unlawful sexual behavior, but on the failure to report crimes. It's on every crime. We also discussed that really, as prosecutors, we have an ethical duty to ensure that we are proceeding forward with charges that have a likelihood of success at a trial. So we really look above and beyond probable cause, which is just the likelihood or probability, reasonable probability that a crime was committed and this person committed it. And we go above and beyond that with the likelihood of having a conviction at trial, and not because of the need to get convictions or anything, but because of course, the reason that we would not want to pursue crimes and charges against people where there isn't enough evidence and respect that their rights. So that's a little bit about the discretion that we have. And I really want to make that an important point, because I think a lot of what we've talked about in this task force is some of the fears of mandatory reporters to be held, criminally liable or criminally responsible if they fail to report, and the difficulties that they have in making those decisions. And as we'll get into the data, we'll talk more about how those cases are handled in Colorado. But I want to really emphasize that when prosecutors see this information, not only do they have that duty to say, I have the facts that meet this crime, but I also have to ensure that there's a likelihood of success. I'll also say that prosecutors use their discretion not to file criminal charges even when the elements are met, due to mitigating circumstances, defenses that we anticipate would be likely at trial, all sorts of things. So it's really a heavy power and responsibility. And I like to think that even though not everybody's perfect, we use it pretty well in Colorado. So I'm going to focus here on the mandatory or the failure to report crime in Colorado. And so I've kind of laid it out in bullet points the way that a prosecutor would be reviewing an instance where a mandatory reporter failed to report. I laid it out in bullet points because we look at each crime and break it down into elements. And those elements are the different pieces that have to be proven if we were looking at charging a case. So any person obviously there's that long list that you all are familiar with of mandatory reporters who has reasonable cause to know or suspect that a child has been subjected to abuse or neglect, or has observed child being subjected to circumstances or conditions that would reasonably result in abuse or neglect, shall immediately upon receiving such information, report or cause a report to be made to the county department, local law enforcement, or through the child abuse reporting hotline system. So I highlighted a couple things here that I think get confusing for mandatory reporters and are confusing, honestly, for us as prosecutors when we're reviewing whether or not to charge a failure to report. The reasonable cause to know or suspect is kind of a very unique legal term in Colorado. We usually refer to terms like reasonable suspicion or probable cause. This reasonable cause to know or suspect is kind of a unique term, and we tend to equate it with reasonable suspicion. So it's really a low bar of that somebody has a suspicion of child abuse or neglect, or has observed that, or observed circumstances, and that then they shall, meaning of course that there's no choice, that it's mandatory for them to report immediately. Immediately is another term that we struggle with, because again, I think in reality, when district attorneys are reviewing these cases, we look at them as that most mandatory reporters are close with families, close with children, know a lot of the parties involved, And of course, that human aspect comes in where they want to be thoughtful and think through, do I have enough information to report this? And their own emotions and own, internal concerns are coming into play. We also, I think, recognize as prosecutors, again, within our discretion, considering reality, teachers that, have a full set of classes and are going through the need to pause and report, or whether it's at the end of the day, or whether they've consulted with other professionals. And so I think this is where a lot of our discretion comes into play, and not charging failure to report if it's not done, immediately in that second. I think that most of us honestly probably provide leeway with understanding if there's good cause to not report it right away and drop everything. And so I just want to kind of lay that out in terms of the reality of how we view this law and how we use our discretion in order to ensure that it's being wielded properly. I wanted to also point out to Colorado Revised Statute 12-240-139. That's a separate reporting requirement specifically when it comes to medical personnel. So we're not talking about that, but I did want to point out that there are special, obviously, reporting requirements for medical personnel when it comes to gunshot wounds, stab wounds, domestic violence. We're not really focused on that, but there are multiple statutes that reference this sort of obligation. And so there are exceptions to the rule, and this is also in 19-3-304, when the person does not, who otherwise is required to report, doesn't learn about it until after the potential victim is 18 or older, and they do not have cause to know or suspect that the perpetrator is doing this to someone else under 18 or is in a position of trust. This is pretty rare. We all are pretty well known within the DA community about when failure to report applies. So I don't really see this exception happening a lot. And then there is an exception for clergy only with regards to their special privileges if that communication has been made in conversation with clergy. So the possible consequences for failure to report are that it's a Class 2 misdemeanor. It used to be a Class 3 misdemeanor when there were 3 classes. 2 years ago, the legislature, we passed a bill to reform a lot of the misdemeanor laws, and we got rid of the Class 3 misdemeanor. And there are now only Class 1 and Class 2, as well as petty offenses. So this remained a Class 2 misdemeanor. The possible penalties include diversion, which looks usually like a DA's office that screens the case, decides it doesn't need to be officially charged, but wants to connect the person with services and require that that's done in order to not charge it at all. Or deferred prosecution, kind of similar, but one step down. This is the most common sort of thing I see in failure to report cases. A person has been charged with it. They come to court and we talk through the option of, okay, let's go get you more training on this. We think that this was a training issue. We're not seeing any sort of ill intent or bad player involvement in terms of trying to sweep things under the rug or, inappropriately protect like an institution. Most cases, we don't see those, not like, I don't have stats, but 90% of the cases, it's just difficult circumstances and no ill intent. So we'll often say, okay, let's go take some training, make sure you're up to speed and you understand your obligations, and then we'll dismiss at the next court date. And so that's probably the most common option in these cases, again, because these are we recognize that mandatory reporters are individuals who are there to help families and help kids in most every circumstance that they're in. And very rarely do they have ill intent with their decision or their failure to report. It's usually a failure rather than an intent situation. Then there's also deferred sentences. Say it is a little more aggravated or a person has a history of failing to report, then we might look at a deferred sentence where we say, how about you're going to plead guilty but we're going to put you on, probation for 12 months. You're going to get training. You're going to do some community service. You're going to be ensured that, we're trying to mitigate the possibility of this happening again. And as an incentive, at the end of that 12 months, we'll go back and basically dismiss the case so that it didn't appear again. So that's a little more aggravated. And then, of course, there's offers where, or results of consequences where a person either pleads guilty or is found guilty and they're placed on official probation. And that conviction is there. They could face the possibility under the statute if every class 2 misdemeanor carries up to 120 days in jail and up to a $750 fine. I have never seen a failure to report carry jail time, and I have never seen a fine imposed. And we'll go through the data that we pulled that actually in the last 10 years, no one has been sentenced to jail for failure to report. The other kind of interesting and very unique to this crime consequence is the liability for damages that are proximately caused. And what I didn't really quite have time to totally dig deep into the legislative history of this portion of the statute, but essentially, to me, that allows kind of a civil remedy to occur in the criminal case. In no other criminal statute is there really existence for damages to be paid by someone. That's really a very civil remedy, not a criminal remedy. But in looking through everything, I believe that was set up because of, things like malpractice, things like licensed people and institutions that carry a certain duty. And if they neglect that duty, then I think that this allows for those actual monetary damages to be considered. And so it's kind of a really unique mix into civil law. Of course, there's other consequences outside of criminal, and that includes licenses. A lot of mandatory reporters carry certain licenses, and DORA is going to be potentially involved in a case where there's failure to report. There's no automatic, if somebody is charged with failure to report or even convicted of failure to report, there's no automatic removal of licensure. A person would still go through a complaint process and a due process with DORA in order for DORA to determine whether there should be an impact on someone's license. But I put some notes in there as well that complaint boards cannot require individuals or businesses to refund money or provide civil types of remedies of filing of lawsuits. So that's strictly a licensure potential. I'll note I don't know that DAs, when we get failures to report, I don't think it's common practice for us to make any sort of report to DORA. That's really outside of our scope of our duties. But I, of course, do think it's a possibility when those issues are raised. And then, of course, there's the potential for civil liability. Like I said, I'm a prosecutor, not a civil attorney, and I honestly, I didn't have time to really delve deep into the potential civil consequences, other than the unique kind of mix over with the criminal case of liability for damages. But there are civil claims out there for negligence and civil claims regarding if somebody had a duty, they were negligent in that duty, and they contributed to harm. I did find a case out of California years ago where it was a doctor who really failed not only to report the injuries and suspected child abuse of an 11-month-old with a pretty severe femur fracture that he should have known was likely to be caused by like a twisting sort of injury. The child had bruises all over its back, or his or her back, I'm sorry. And they not only failed to report, but really failed to recognize the potential harm and medical consequences there. And so in California, then that child went home with the family. They were abused again and brought back into the hospital. And at that point, they reported, and the doctor was later successfully sued for, like I said, that failure to, that duty that he had for care, that failure and neglect to report and respond appropriately medically. And it turned out that those parents, of course, were arrested and for child abuse. So the interesting part is that child abuse, the failure to report statute sits in Title 19, and bear with me while I go a little like legal here. It sits in Title 19, which is a children's code. Most crimes do not sit in Title 19. They sit in Title 18, which is the criminal code. And why that matters is because then the definition for what abuse or neglect is and a failure to report that suspected abuse or neglect sits in the definition in Title 19, whereas the criminal definition of child abuse or neglect sits in Title 18, and that's 18-6-401. So they're completely different definitions of what we charge criminally for child abuse and neglect and what a mandatory reporter is charged with if they know, well, I shouldn't say charged with, is expected to report. So I think that's kind of an important note. You all, I think, are pretty aware of these, but you can see it's a pretty broad definition. We have that obvious evidence of injury, subjected to unlawful sexual behavior. Again, that's a cross-reference back to Title 16, which actually covers offenses that require sexual offense registration. So that's kind of an interesting crossover. But that's one thing that I commonly see as an issue, is that there's a lot of having to cross-reference, okay, multiple statutes when determining whether to report. Need of services for failure to take actions that a prudent parent would take, emotional abuse. And then there's another reference to a statute, and then I included that cross-reference here where there's abandonment, mistreatment, subjected to mistreatment or allowed another to mistreat, the child lacks proper parental care, or the child's environment is injurious. I'll tell you, in my experience, the most common thing that we see with failure to report is when a mandatory reporter has failed to report and they had reasonable cause to know or suspect unlawful sexual behavior, or the child's environment is injurious to his or her welfare. Those are the most common ones that I think that we see. It continues on, of course, that where a child is residing or found there, where controlled substances are being manufactured, or they're born with alcohol or substance abuse effects, or subject to human trafficking. So moving on to the data analysis, what we did is through the CDAC, we run and provide Action, which is a software case management program that is basically provided to all 22 district attorney's offices. And that's where all of their cases are stored, all of their discovery is stored, all of their notes regarding the case. Everything that they work through on that case is now done on Action. And it was rather than on paper or anything like that, which is really great because it's a data trove, treasure trove of data where we can pull and isolate different factors in different cases and see outcomes and all of it. I put an asterisk next to 22 because Denver County, the second judicial district, didn't join until I believe 2018 or 2019. So this data might be a little bit skewed because of that late joining. Although we were able to pull most of their data from their servers and add it kind of backwards into Action. I just don't know that it's perfect. So I looked at 2010 to 2020 charges for failure to report, looked at all the outcomes. And of course, I'm sharing with you aggregate information. I'm not providing any names or identifying information to keep all that confidential. So when I looked at all of the cases that were charged for failure to report, so this wouldn't include anything that was that had gone through pre-charging diversion, but honestly, that's only available in certain counties. So I think this captures pretty well every case where law enforcement determined that there was a failure to report, enough evidence to present it to the district attorney's office, and the district attorney's office filed a complaint on that failure to report. There were 70 cases from 2010 to 2020. And as you can see, almost 60% of those were ultimately dismissed. I can't necessarily see where in the case they were dismissed. So I don't know if that was, at the first or second court date or later on in the case. But that is the majority outcome. Personally, anecdotally, from my experience in working with and training these DAs and consulting with them, especially on these cases, which we just handle very sensitively, the majority outcome is when somebody has offered that deferred prosecution that I described earlier, where they come to court after there's a charge and then are offered to go complete training, show proof of that training, and come back and have the case dismissed. That's my belief of why the majority of these cases are dismissed, because that's the typical outcome or the typical plea offer. A number 19 people have been found guilty over that 10-year span. One was acquitted. I'll take one for the team and actually say that was my case. I tried it and there was an acquittal, and perhaps later we'll talk more about the reasons for that. And then there were a number that had gone through pretrial diversion. And then there were 4 cases where the data just said null. So I really don't know about the outcome of those. It's likely that, well, I don't know exactly why I can't see the outcome of those. So then I went through the 19 that were found guilty and wanted to show the breakdown of that 60% of those were provided deferred sentences. And every single one of those deferred sentences, those 11, were completed successfully. So they had those cases dismissed ultimately. I don't include those in the 41. Those are separate. So ultimately they pled guilty, completed their deferred sentence successfully, and the case was dismissed. Only 8 resulted in probation. All of those were successful probation. And again, none of these carried any jail sentence. I didn't really double check for fine, but like I said, it's incredibly rare for a judge to impose a fine. And so I'm highly doubtful that that was imposed. Kind of final issue that I want to share with you is, as we've been talking about this more in relation to our conversations with the task force, like I said, I think our focus, rightfully so, has been on more of the child welfare aspect of it. And I want to kind of expand and talk through, of course, as a prosecutor, that the impact of the mandatory reporting law is not just on, looking at parents or families, but includes reporting for when there's unlawful sexual behavior between peers at school, or siblings or other family members. Unfortunately, I don't think I have to share it with this group, but we all know that the vast majority, 90+% of child sexual assault happens with somebody that they know and that they're close to. And so that's outside of family, can be coaches, teachers are the result of our mandatory reporters lead us into investigations into these parties, other people in positions of trust, babysitters, people who have common associations with or opportunity to have contact with children. And also, even though it's rarer, strangers and acquaintances that abuse children. And so from a prosecution perspective, this mandatory reporting law allows us to hold those people responsible and keep those people, or keep children safe from those parties as well. So I just kind of wanted to share, in my perspective, the broad impact of it. And I think that's it. Yeah.
Thanks, Jessica. Really appreciate that. I'm like sitting here thinking, is all this in your brain? And you know how to play chess? That's amazing. How much?
I'm not very good at, I didn't say I was a good chess player.
Okay.
I just said I'd like to play.
Yeah.
I have a big failure rate. Yeah.
Okay. All right. All right. Well, thank you for that. Like, incredible presentation. I think Doris is going to jump in just to make sure we don't have any questions here, and then we'll keep going. Go ahead, Doris.
Yeah, and I was watching Jessica as she was presenting, and I think the answer is yes. All this was in her head. We're gonna open it up for questions, and I see Zane and Jade, you have your hand raised. I do want to come back to before I turn the floor over, and because I have the mic, the pie chart that you showed, Jessica, of the prosecutions. Do you have a sense of what kinds of incidents were not reported in those? Were they mostly in those that were where there was some prosecution and then kind of what the outcome was? Were they mostly like sexual abuse, or were they the whole range of reportable kinds of behaviors or incidents?
Yeah, that's a good question. I can look at all of them, or most all of them, and see what they were, and even identify the ones that were, officially convicted, which were almost all plea convictions, not trial. I will say, so I don't know specifically what the underlying incidents. In my experience, the majority of failures to report come from unlawful sexual behavior, and I think, unfortunately, a lot of people are like, it's a he said, she said, it's a gray area, I don't know. And I kind of hate those terms. But I think that is where there's a lot of concern. I don't know if I have enough information to report. And I have concerns because I know both of these teenage kids, and I think he's a great person and she wouldn't lie to me. And, there's just a lot of difficulty with those. In my experience, that's probably the vast majority, is on the unlawful sexual behavior. But I can definitely take a look. I'm happy to and follow up.
Yeah, I think so. The thing that came to mind is as we think about, potentially looking at, we've talked about that neglect category, and then it was as we think about what might be a narrowing of the categories for which mandatory reporting might apply. I think it might be helpful for the group to have an understanding of the kinds of incidents that were like successfully prosecuted for failure to report.
Definitely.
Thank you. Zane, we'll come to you next.
Jessica, great job. I guess I have more probably of a comment to just chime in on. And I just wanted to say thank you for bringing up the licensure issue. I don't represent Dora on this at all, but I am the board chair currently for the Unlicensed Psychotherapy Board, and I was the former board chair of the Social Work Licensure Board. And so personally speaking, always have to make that reference for Dora. Personally speaking, my experience and my time on the Dora board has taught me a lot, but we have had cases where we have had to take action against professionals or licensed individuals for not reporting in certain circumstances. And you're right, we've never received any kind of report from that I am aware of from a prosecuting attorney. We've had other attorneys, file those cases probably more civilly than criminally. But it is something to be aware of. And I would say that most professionals probably don't really make that tie-in between, their obligation to report and the fact that it could be an issue for their licensure board or their certification board if they don't. So thank you for bringing that up.
That was a great call. A lot about that potential consequence to mandatory reporters. Jade?
Thanks, Doris. Yes, thank you so much, Jessica. I have I'm not sure if it's a question or a comment. I think where I'm a little curious is, I think a lot of this is also around public perception. So I appreciate that your presentation today was really grounded in data and what actually happens around prosecutions. And I believe there is kind of public perception that this is kind of more frequent than it is, or kind of maybe some public perception that just how devastating that could be if charged with failure to report. And I think that drives a lot of decision making at times. And so I think that's just a comment that I really appreciate that this was grounded in data, because I do believe that the public perception is different. I think the other thing that is coming up for me is around the reasonable cause to know or suspect. It's personally one of the things that I really struggle with because, again, I think public perception is that reasonable cause to know or suspect might mean one thing. And when you say from the law, it equates to reasonable suspicion or it equates to something that you all are looking to prove, that makes a lot of sense. But in my head, when I am wondering if this is something I have to report, I feel like I can make an argument that reasonable cause to know or suspect that, child abuses occur or may occur, is a pretty broad definition. And I'm wondering if you can speak to anything about what you've seen in other states or what you see in other places in statute where maybe that could be narrowed a touch, if you have any thoughts or ideas on that.
Yeah, well, I agree. I think it is confusing. I think the closest thing we have to that terminology is reasonable suspicion, but that's really grounded in law enforcement, right? Law enforcement is trained on what reasonable suspicion is. And to give context, reasonable suspicion is the standard that's used to, pull someone over in a traffic stop and hold them there and talk to them for some period of time. It's lower than probable cause in the terms of like the hierarchy of burdens of proof. Beyond a reasonable doubt's at the top, we have clear and convincing, probable cause, and reasonable suspicion is the very bottom. So it is hard. I don't know if, most other statutes either have, most other criminal statutes have what we call mens reas, and mens reas and the hierarchy go from intentionally, knowingly, negligently, recklessly, carelessly. I want to say that's right. I actually have a little hierarchy I could pull up. And so usually a crime is committed with one of those thought processes, whereas failure to report is unique because it's a failure, right? It's not an intentional act, it's an omission. And so those are kind of the thoughts that I have, I guess, when I go through and think how odd it is to see reasonable cause to know or suspect. I do think personally that the intent is that it is the very barest amount of suspicion because of the need, overwhelming need to alert authorities who then can go in and investigate, and the experts can look at, okay, is there more to this than the bare suspicion? That's how I tend to see it. But yeah, I'd have to look more into other states. I know that CPO, Stephanie and her team have looked into a number of other state statutes regarding failure to report. And maybe that's something that as a working group that we could focus on to make it more clear to reporters and to prosecutors who are considering whether or not there's a charge there.
I just have one very quick follow-up question. Could the standards be different in the same statute? So for example, could there be a different standard around neglect than there is around unlawful sexual activity, or would that be too complicated in statute?
I mean, it's certainly possible, right? And I think that is really coming into the idea of legislative drafting and how, and this would be a good, obviously, another task for a working group, in my opinion, to have some breakdown of what that would look like in practice, how it would be trained, how it would be differentiated between those two. But right now, right, it does encompass, you saw the definition of child abuse and neglect includes things like that they're, what was it, the term that parents are failing to take the same actions to provide adequate food or shelter that a prudent parent would take. To me, that's probably the subsection that we're talking about, where there's a lot of discrepancy between how that is handled and how that is applied. And so there are ways that could be broken down to different types of abuse or neglect are subject to different standards. I'm not going to give an opinion on whether that's a good idea because I'd have to think through a lot more. But sure, it's statutes, right? Legislators can move and meld and write them, and we just hope to give them the insight and the advice on whether that makes sense.
Awesome. So that, I mean, I think you made the point, Jessica, that is certainly presents an opportunity to go deeper in a working group to really, dive deeper into both the data and the potentials for draft language. Roshan, and then we'll come to Michelle. Is it Roshan or Roshan?
Roshan.
I thought it was, as I was saying, I was like, I think it's Roshan. Thank you.
I answered all of it though, because it confuses folks. And so thanks, Jessica. That's so super helpful. And I agree that this public perception is so different than reality on this. And so it's very helpful to get the stats. So thank you. It's also great, just your role, it's just great that we have this role in Colorado. We're really excited about that too. I don't know if Jessica, this is a question. I don't know if you can answer this, and maybe Zane, it's more a question for you. It came from what you shared in your question, but one of the things that comes up a lot for DV advocates, at least, is that there are different requirements in your role as a DV advocate, and if you are a licensed therapist, for example. And so, and oftentimes people might have a therapy license, but they're not using it as an advocate. They're not hired as an advocate. They're not hired as a counselor. They're not being paid as a counselor. That's not their role, but they do have a license. And so they're dealing with multiple types of, so the roles are different. So they have to remember that. And we've actually spent a lot of time with Dora trying to get some answers around like so if you're acting as an advocate, and not using your license, and you hear something that as a therapist you would have to report, but as an advocate you don't, like, what is there a risk? And we have not been able to get any answers. Everyone's like, we're not sure, we don't know. So one, just to name that as like another reason that the statute is very confusing, and it would be great to once again pull DV advocates out of it. But also, if anybody has thoughts about how, or if you've seen anything like that, Jessica, my guess is definitely not, given the numbers you just shared, but it really comes up a lot for us. And Jen, I'm sure you've seen it even more than I have.
Yeah, no, I think that's more, I don't have much answer for it, but I do think that that's a good point in the potential discrepancies. One thing to talk about too, right, is in your capacity. I know there's a question out there of when does this duty stop? Should there be a number of states do have when in your capacity, and that might go to helping differentiate, if you're working in your capacity as an advocate, should it affect your therapeutic license if you fail to report as an advocate, right? That's a good question. I'm interested in Zane's thoughts on it, and really more from the Dora perspective, but.
So again, I just want to be clear that I'm not, representing Dora, or I'm not legal counsel or anything like that. So I don't want to get myself in trouble. But from my experience, what I've learned is that if you have a license or a registration or a certificate, the board that you respond to has jurisdiction over you, no matter what activity you are involved with at that time. So, and this sounds to me like the same thing, like when I'm talking to, and I'm doing mandatory reporter training, I'm an LCSW. And if I go to Walmart and I observe a child being subjected to certain circumstances, I think my obligation as a mandatory reporter is to report that. So even though I understand the question about, the role of being that DV advocate that was brought up, I just don't think the statute gives us enough clarity to say you're off the hook. And that's where I think this task force will be very helpful, because I do think we need to have some better guidelines, because when are you on the clock and when are you off the clock? And when I'm doing trainings, I'm basically saying, if you hold any kind of credential and a mandatory reporter, you're on the clock at all times.
And that's the training I received as a therapist was, in your driveway, in the department store, and you're never not. And we've also heard that doesn't always apply. So just to your point, it's not clear. And so it'd be great to clear it up a little bit.
I also just want to throw out there that that is a directive that we'll be getting into. So just not to say we have to put that on the shelf, but just want to remind us of that. Thanks, Roshan.
Thank you for that, Trace.
Yep. Do we want to move? A couple more questions, and then Doris, I want to make sure that we have plenty of time for Adriana as well.
Yep. That was the plan. So we'll go with, if I saw Michelle, Jennifer, and then you, Nikki, just sort of really quickly, we'll have another chance to ask questions. And Jessica and Adriana are both going to be joining us on the panel. So we'll have some more time to go deeper as well. But just sort of sticking with the presentation that Jessica provided and the data that she shared, we'll go to you, Jennifer. Michelle, Jennifer, and I don't remember the order I just said. We'll go to you, Michelle, because you took your hand down, Jennifer, and then Nikki.
Yeah, I just was gonna, that was the point after Jade talked about, we get a lot of confusion from mandatory reporters about whether they're required to report in not only their professional lives, but their personal lives. And we have interpreted and believe that the statute does not allow for the delineation between when you're on duty and off duty. It doesn't say Monday through Friday from 8 to 4:30 or during your business hours. And so that I believe and understood that we would be addressing that in this task force. And I think it's an absolute important component. So thank you.
Awesome. Thank you, Michelle. Jennifer?
Thank you. Yeah, I first of all just want to echo all of that about the 24/7 being on duty thing, because that's what I was taught as well. But I think in addition to that, the issue that Rashan raised and came up for me personally, professionally, if you have multiple credentials and are operating in a different role, I'm a licensed professional counselor and an attorney. I had to do a bunch of research and talk to a bunch of people when I was in law school to make sure that it was clear, okay, in my role as attorney, I am not a mandatory reporter. In fact, I can't report in most circumstances, right? But we need that to be clarified, I think, in statute as well, because that really is unclear. And for victim advocates, as Roshan was talking about, if someone is operating as a victim advocate and they have a license or are registered with DORA in whatever way, then the worry about risking their license in a role that is not associated, where they're not technically using that license, raises concerns. And so I just want to say, I don't know if that's at all in our responsibilities, but I think it goes hand in hand with this. Are you on duty as a mandatory reporter 24/7?
Thank you, Jennifer. Nikki?
I was just curious if Jessica had data on if on those convictions or pleas, if they were operating within their capacity and failed to report, or outside of their capacity, since we're having this conversation.
Yeah, it's a good question. I don't. What I really pulled was the aggregate, like name, case number, charge, outcome. It doesn't come with necessarily the facts. If I do have pretty good access to be able to look at those underlying facts if those reports are available to me. So I can certainly take a look at those. I'm happy to look at, especially I can look at all of the. I can look at all 70. I can also narrow it down and look at the 19 that were actually pled guilty or convicted, if that helps, and see what I can come up with. I'm happy to follow up with that and put together like a little summary of it for Trace and Jordan and the team to provide.
Awesome. Thank you, Jessica. And thank you, Nikki. All right. I think we're going to turn it over to Adriana Hartley. If you could introduce yourself, and then I know you're going to provide us with a rich, thought-provoking presentation as well.
Thank you. There's no pressure in following up with that. No, my name is Adriana Hartley, and I am an assistant county attorney for Delta County. For those of you that don't know, Delta County is a medium-sized county, beautifully wedged right under Mesa County and on top of Montrose County. As an assistant county attorney, I generally provide advice and representation to all departments within the county. This includes advising caseworkers who work for the Delta County Department of Human Services. I am so jazzed that Jessica went first. I'm going to be so on board with a lot of the things that she has presented as well, but I am not a district attorney. It is not my role to prosecute these crimes. Really what that looks like for my day-to-day is caseworkers coming to me as the county attorney and saying, during our investigation, during the process of receiving this report, I have discovered that there was a mandatory reporter who did not notify the department, who didn't call the hotline. What do we do with this information? I like to believe I have a close working relationship with that department as a whole. I am unfortunate that in this county, at least, my office has significant, if not daily, interactions with our caseworkers. So it's often that we are staffing issues which generally impact the caseworkers pending investigations. And like I said, this kind of can include what steps are taken when it's discovered a mandatory reporter has perhaps failed to make that report. Talking a little bit on the perceptions of the myths, or at least my perceptions of the myths that surround a failure to make a mandatory report. I'm going to start in typical attorney fashion by prefacing my spiel with kind of three broad statements. First, I'm only speaking to my experience in Delta County. In making these statements, I have not reached out to the other counties, although I do believe there are a lot of counties across the state that have a very similar approach. Second, my information is from a general review. Like Jessica, I did not pool and analyze every single investigation that DHS has done out here. My numbers are kind of not meant to be scientific data, so please don't hold me to it as an exact. But third, and I am glad to hear that Jessica kind of opened the gate to this as well. I'll further dive into this. I have a deep respect for the district attorney's office. Clearly, I respect the criminal justice system as a whole. My big broad to point to the things that the questions have already been asked is about these perceptions. You know, in making these statements, I am not in any way encouraging any mandatory reporters not to make reports or adhere to the law. So please don't walk away with that notion. With that said, I think the biggest myth surrounding the failure to make a mandatory report is that this office, so the county attorney's office, and representing the caseworker and on behalf of the department as a whole, we're just rushing to the district attorney's office if it's discovered that a mandatory reporter has failed their duty, right? And we kind of see that when we initially started, one of the concerns that was reported or the motivations in making these reports is concerns about the legal liability. You know, there seems to be this perception or this fear that the department is actively seeking to penalize mandatory reporters by referring them over to either law enforcement or the district attorney. Frankly, in my opinion, this fear and this tension is kind of so pervasive among the community that I think it skewed some of the data and the analysis that this group has even been working with. To Jessica's point, like, we're not seeing these charges come about. We're not seeing these referrals being made through law enforcement to the district attorney's office. And so when I see that one of the motivations or top three motivations in mandatory reporters making referrals is kind of the legal liability, I kind of question that myself personally. I don't think that's not a motivation, but I don't think that matches with the data or the reality that we have been experiencing. And I say this because when I initially sat down to really think about how often our department discovers instances of a failure to make a mandatory report, I thought it was my initial guess that maybe this occurred in about 25 to 30% of all child welfare cases in Delta County. When I then just kind of asked, without any prep of the intake team, the same question, those caseworkers right off the bat kind of unanimously felt it occurs in about 40% of all of their investigations. So that means for Delta County, at least, our intake team feels about 40% of their investigations somehow leads them to a mandatory reporter or somebody who had knowledge or information about the situation, who maybe should have made that report or that referral either to the hotline or to Delta Counties directly. The truth of my experience is that it's just so common in handling investigations. There's a lot of information contained by a lot of different people. They clearly don't necessarily always connect. And so they don't have the big picture or the luxury of the big picture that a caseworker might get in hindsight during their investigation. But it's oftentimes that our intake team is touching on a mandatory reporter who has knowledge or has something that helps the caseworker develop what needs to happen next in their investigation. What's more, in the 6 or so years that I've been handling child welfare cases in Colorado, I have advised and assisted the department only once in turning over this information to the district attorneys for possible criminal persecution. Just one. You know, I don't want to go into the specifics of that case, but let's just say this was the outlier and the exception to the rule, because I felt at that stage the department as a whole had tried to work extensively with this individual and gaining understanding of why it's important to make these reports. And every single attempt that the caseworkers in the department as a whole had made by that stage just weren't effective. And so, you know, that's not to say that our department just ignores the failure to report. When it becomes obvious to a caseworker, that caseworker typically follows up with that mandatory reporter and tries to educate and offer assistance in understanding why their report and their information is critical. Why is this the Delta County approach? Because I get asked that sometimes. I think the department and our caseworkers as a whole clearly are dependent upon the mandatory reporters, right? It's this very unique symbiotic relationship. The department does not have the eyes or the ears on these families like, say, a teacher would, for example. I think the fear of persecution or concerns about legal liability does not encourage more reports, rather causes mandatory reporters to question their own judgment about what is abuse or neglect. These mandatory reporters typically have the established relationships with these families, and they know the impact that may come with the department's involvement. We've talked about that previously in this task force. It's my experience that when a mandatory reporter suspects abuse or neglect, they are not calling that into the hotline. They want to be certain. And these reporters in turn may conduct their own quasi-investigation or may push to gather more information. You know, it's become common for a mandatory reporter to tell a caseworker, or, you know, just when we're trying to offer this education, you know, well, does this really count as abuse? And it's not because they're being coy. It's not like it's an honest and legitimate question. Does this rise to the level of abuse? Does this rise to the level of suspicion? Because I think Jessica really did highlight that on her presentation as well. You know, it's kind of obvious the reason to know. You know, if you see it, that becomes reason to know. But what is suspicion? How does one even define a suspicion? And so, you know, it's my belief that these reporters start to feel compelled to make their own independent determination of whether abuse or neglect is actually occurring, and only then do they make the call. And I think there's a lot of good intention to that. That's not necessarily a bad approach, but this can be wildly concerning because some mandatory reporters may have no knowledge or training on what is actually abuse or neglect. And how can they when it's not even well defined in the law? I loved that Jessica pulled out some of the Children's Code or the Title 19 definitions, but as a county attorney that does dependency and neglect cases, right? So once they do actually go, DHS is seeking custody of those kids, we turn it over to a DNN or a dependency and neglect case. The definition of what abuse or neglect, what counts as abuse or neglect, can just be wildly broad and so different from case to case to case. So to some degree, I think, you know, the law needs to be written in a vague way to make sure that we are catching all of these instances of abuse or neglect, you know, because the more you start to define it specifically, the more there's going to be those people that are like, oh, that doesn't count. But we have put, legally speaking, in the plain text of the law, we've put mandatory reporters in kind of a really impossible position, in which the law itself does not even want to define or abuse or neglect, or even what suspicion means in these instances. But we expect mandatory reporters without any training or knowledge that's been formalized to just know. And we see that this kind of does skew the reports that we get. We might have a mandatory reporter who reports everything to the department, and then we might have a mandatory reporter who reports nothing to the department. And so I think there really needs to be a focus on some of that in the legal piece of how we correct some of this just ambiguity. We certainly don't want to push the responsibility of knowing what abuse or neglect is to mandatory reporters, right? That's not their role. A lot of them are therapists or medical providers. We don't want to add to that hat, especially when there are licensed and trained caseworkers for departments. You know, it should not shift that burden to them. But at the same time, if we just leave this so vague and open, it does become this skewed result. I am sensitive, clearly, to the data that's been presented. I'm sensitive to the impact that the department has when they might intervene in the lives of a family unit. But it's also important not to lose sight that oftentimes mandatory reports are the catalyst which protect these children. And that's why it's written in law, and that's why it does, you know, it's important to keep it in the law. Whether it's the fear of legal liability in failing to report, or the fear of legal liability in making a report, I am advocating very strongly that we need to move away from the fear altogether. Looking at Jessica's stats and the data that has been provided, clearly it has not been an effective motivator for the behaviors we want to see. The purpose is, generally speaking, offering protection for these children who may be subjected to abuse or neglect. These mandatory reporters need to feel that making a report is a safe, if not hopefully positive, resource to utilize in the law. I know it has not been viewed that way. I know it hasn't been used that way. So again, I'm sensitive to that, but it's amazing to me to hear that even the district attorney's office is looking at this of these mandatory reporters, generally speaking, do not have ill intent. They are not just turning a willful and blind eye. So, like I said, we need to move away from this criminality mindset, this fear-based model that says you face criminal penalties. Instead, we need to create a system as a whole where people don't view reports as this scary, mysterious, time-consuming process. We don't need them to weigh, you know, is this suspicion enough? Is this abuse or neglect enough? We need to open the doors to just making a report in which other professionals like caseworkers continue to follow up and make that determination. But I am sensitive that it's not currently viewed as a positive resource, and that is unfortunate that has been the outcome, because I think, you know, there is potential there and it does need to remain in the law. But again, we need to just step away from penalizing those that have no backing or no support in determining what abuse and neglect may be. And I lost my train of thought because I kind of got in there. Yeah, it's very, yeah, I think, you know, as a whole, it's very interesting to see a very broad, vague term, but then to be faced with criminal penalties, you know, education, in my opinion, and to the point of Jessica and district attorneys offering probation, offering training, offering diversion. You know, when we appropriately educate mandatory reporters And when mandatory reporters have a transparent and honest understanding of the role of the department, and we have a clear understanding of the process of the department's investigation, only then I think will people be motivated to utilize the hotline as it was intended. This cannot happen when we just flatly tell mandatory reporters to report or face the consequences, without offering that necessary support and training in the system. So I think that there's just a lot of potential for change. And even the plain text of the law, I'm excited to kind of break off and dive into that a little deeper.
Thanks, Adriana. I really appreciate you coming and sharing all that information. I want to, before I open it up to questions from folks, just want to clarify that we're going to come back and do more of a panel discussion, but I do want to see if folks have any clarifying questions for anything that Adriana shared, and then Adriana will be back for the panel discussion where we'll kind of get more into the conversation. Go ahead, Zane, I see your hand up.
Sorry, I put this in the chat box too. I was just curious, in your experience, when I was a caseworker years ago, our head county attorney told me at that time that mandatory reporters aren't considered anonymous. I think a lot of mandatory reporters think that when they call a department that there's an anonymous factor to that, and that they won't be revealed to the family. But I was told the opposite, that mandatory reporters can be called in to testify under a DNN. I haven't seen this happen in my 25 years working in child welfare, but I was just curious if that would be your take on that as well.
Yeah, I don't feel, so I wrote this in kind of our Google survey as well. There is this wild perception that mandatory reporters are not entitled to anonymity, that they have to inform their clients that they are making a report, or even worse, that they have to have the client present when they are making that report. I will tell you, I can't speak to the best practice or the individual approach for each professional, but the law does not require that at all. Mandatory reporters are equally entitled to anonymity if they choose to make that report. And more so, I personally and professionally value the anonymity of a mandatory reporter, regardless of whether they've given their name to the report or not. Meaning, I have never ever called or subpoenaed anybody that has made a report to the hotline or to the Department of Human Services to serve as a witness. Anytime that information is requested, it is heavily redacted out of this office. It would not be my approach, because I think we have to honor that part in the system as well. People, again, in the hopes of creating the safe space, I think we need to offer and continue to offer anonymity to those that want to make reports.
So then how would mandatory reporters, Jessica, convince you that they made a report, but it was anonymous?
So that's what I was going to say. Certainly, there's no anonymity when a mandatory reporter calls in a case and that case is then investigated and becomes a prosecution. We will call in almost every case. I mean, any case where I have a report, whether it's mandatory or not, I'm going to call as a witness that person who made the report because they serve as an outcry witness and can corroborate a victim's statements. And so honestly, the way we get it, and this is a good discussion for this too on best practices, is that usually say somebody calls into DHS, a mandatory reporter calls into DHS and law enforcement might call into law enforcement, and then DHS is brought in through law enforcement because maybe it's a familial case, and then I'm going to request those DHS records. And I'm going to get the information of the mandatory reporter because it's necessary for prosecution, and it's necessary for the defendant to be able to have, because the defendant has constitutional rights to confront witnesses against them, and they have the right to be able to have that witnesses identifying information and call them as a witness if they wish. I've never done it at a preliminary hearing. It has happened at motions hearings because we have, as district attorneys, sometimes we have to file motions regarding child hearsay. And so statements that were made to a mandatory reporter fall into child hearsay statutes. And sometimes we have to call and examine at a motions hearing and sometimes at a trial. So I actually have in this rare instance, a different opinion than Adriana, because I do think it's important that with the conflict of criminal obligations and discovery obligations, there has to be the ability for that person to not be anonymous. Now, if they call in and anonymous and don't provide any information, certainly I think that's their right. We're probably going to figure it out. Like law enforcement's probably going to figure it out in order to investigate their case. And be able to contact that person as a witness. I've personally never seen it. I've never seen a mandatory reporter call in confidential when the case has then become, a criminal investigation, because they tend to be pretty invested in helping out and making sure that the evidence is available to law enforcement for that case.
And to Jessica's point, dependency and neglect actions are civil in nature too. So the rules of evidence, the rules of discovery, it's very, very different. So I do kind of have a little bit more luxury in protecting that information than if it were turned over to a criminal prosecution.
Yeah, and Adriana, I appreciate you kind of making that differentiation there on the civil piece. Any other questions? We're going to go into a break shortly, but want to make sure specifically for Adriana, if you have any questions, again, we'll come back. Clearly plenty to dive into and talk about. All right. I'm not seeing any questions right now. Adriana, again, thanks so much. Jessica, thank you so much for that. Let's give everybody a quick, we're going to do a 10-minute break. So we'll come back at 9:46 on the dot and we'll keep going. Thanks, y'all.
So I will say that I'm still fighting whatever series of viruses I have, and I'm trying to mitigate my throat being on fire with some lemon honey hot water. So if I start coughing uncontrollably, or if it becomes unbearable, Trace, I'm gonna actually ask you to jump in and help me out. So we had the pleasure of hearing from Jessica and Adriana with their presentation, and want to dive into some of the other questions that we've been asking all of our member panelists, and then talking about your experience and recommendations and ideating on ways to move forward. I think Jessica and Adriana, you provided us some glimpses of that, but want to dive deeper. And also we have joining with us on this panel our illustrious co-chair, Stephanie, who is going to step out of her co-chair role for a moment and really join us as a thought partner in sharing out her vast experience in this space, bringing in her legal expertise, her role as the lead of the Ombudsman's office, and just navigating these complexities and playing a lot of defense in some instances, and trying to ensure that we have the best legislative and practice outcomes for kids and families. So Stephanie, if you could just remind folks of your amazing powerhouse background that includes, but it is not only inclusive of your role in the Ombudsman's office.
Well, thanks, Doris, and just thanks to all of you. It's such a fascinating conversation and one that I love. So many of you on this screen are professionals, friends that I have encountered over the last 3 decades of my career, which started at the Denver District Attorney's Office. For 12 years, I worked running the Crimes Against Women and Children's unit there and served as a chief deputy. So Jessica, just hearing you walking through the criminal statutes, just believe it or not, warms my soul at some level. I miss those days. I also spent 4 years at the United States Attorney's Office, prosecuting crimes on federal jurisdiction, primarily human trafficking and, again, child physical and sexual abuse. Was in the governor's office for 4 years, which is where I first got introduced to the civil side of things, right? All the great work done by DHS services, aside from a criminal justice lens. Ran the Rocky Mountain Children's Law Center for 6 years with my friend Jennifer Isle over there. We ran a guardian ad litem law firm, multidisciplinary law firm for many years. So I'm very familiar with all of the DNN proceedings and the processes there. And then I've been in the ombudsman role for 7 years. So where I've also encountered throughout all of this time, a lot of the issues that are before us today as it relates to mandatory reporting, just depending on what seat I was in, it just depends on the nature of the questions that would differ. But ultimately, working on this project has been incredibly helpful to round all those issues up once and for all. I went ahead and put a copy of our issue brief that we published back in, I think it was 21, that initially laid out some of the legal challenges. Jordan went ahead and put into the chat another document where we actually then not only analyzed some of the legal insufficiencies of the law, but also gave a very brief overview of other states and how they're handling the various issues that we have in front of us. So those were some of our attempts at just the springboard process that would allow us to form as we have today. So.
Awesome. Thank you so much, Stephanie. I actually want to start with you. Jessica provided some amazing data on prosecutions, and she provided a lot of context, the legal context that I think was really helpful. And I'll say that over that 10-year period, I was somewhat surprised by the relatively, I think, seemingly low number of prosecutions for failure to report. But then I think about that coupled with all of the data that we've looked at over these series of mandatory reporters, where the vast majority of reports that are called in for child abuse and neglect do come from mandatory reporters. So namely, law enforcement, education officials, and medical professionals. And so it does suggest that there is a pressure, and I don't know if pressure is too strong of a word, to report on child abuse and neglect. So that this idea of the law being a deterrent to not reporting may be a contributor to the volume that we see. And you stated in your survey that that you do hear as one of the reasons for mandatory reporters to make reports a fear of legal liability for failure to report. So I want you to just share a little bit more about that particular theme, and then talk a little bit explicitly about institutional reporters, because you named that group specifically as folks who are especially concerned about not reporting.
Sure. I think that I really appreciated the data, Jessica, that you brought, because it's the real picture, right? And as Adriana also said, it really does right size, if you will, the fear and or the problems that are perceived. What I will say, first of all, just from an ombudsman perspective, right? It's always important to remember where we sit in the system, and we're way downstream. Right? We're way downstream when people have problems and they want, they're seeking answers to questions in some form or fashion, or they have a complaint about the child protection system. As it relates to sort of fear of reporting, I will tell you the biggest number of calls we get is when there is a newspaper story, and I'm going to call out the East High School case that was in Denver already, I think about 4 years ago. My office tracked, I think it was about 6 to 8 high profile cases. There was Prairie Middle School, there's East High School, there was Colorado Springs in a church, right? And those are cases where seemingly, I'll say, the evidence is that somebody chose not to report deliberately or intentionally. That's when our biggest number of calls come in. It is terrifying. After East High School, we had to have had over a dozen calls from teachers going, wait a minute, I didn't think I could be charged with that, right? Or I thought the law said X, or my training taught me Y. And so, Adriana, when you talk about sort of what are the real fears and what are the reality, I will say that we definitely see an increase or an uptick when there are large media stories about this. The second thing I would say, those media narratives definitely shape the fears, right? You never hear a story on mandated reporters saying, we just didn't understand, and let's talk about the complexities of mandatory reporting and how hard it is. That's never been a headline that I've seen in 3 decades, right? It's always about somebody who deliberately and intentionally tried to withhold information. Again, whether those are the facts or not, We don't know. So I would say that that's what our office typically sees when we get the big rise. And then to your second question, Doris, institutional reporting is a huge issue that has come to us. As evidenced in our brief, Children's Hospital was just the latest in a series of cases where we have line workers who are very concerned that they are not reporting directly, but instead are required by their organizational policies to pass that data on to supervisors. I will tell you that I've had a lot of conversations, particularly within hospitals and schools, and they're like, look, it isn't feasible. It is not feasible for line staff, nurses, right? Teachers, teachers' assistants to run off the line and go call a child abuse hotline, right? And so that is why we have a policy. We're not trying to get rid of our responsibilities, but we have to control it because these people otherwise are engaged. The second thing we hear a lot about institutional reporting, Doris, is that people are jeopardizing, they're afraid of jeopardizing relationships. And in the medical context, that especially was apparent. Kathy Wells mentioned this way back during one of our medical panels. But, you know, the idea is you have a treatment team. And if there are 6 medical professionals treating a child and helping their family, and one of those team members runs off and calls the child abuse hotline, what does that do to the sanctity of that treatment? Right? How successful can it be at that point if parents are afraid to talk to the treatment team? So that is how we've seen those two issues come up most frequently.
Thank you for that. And I think that there are a couple of things that I want to come back to that I think are really important points as to institutional reporters. One is the administrative burden, and there's some other themes that I want to pull into that conversation and bring up a recommendation that came from one of you around having another mechanism for making reports. And then also this sort of seeming conflict around there being a potential individual consequence that may be impractical given the kind of the way that someone works in their given role inside a system. And so being able, afforded the luxury of time to step away from your job, whether it's as a teacher, whether it's as a medical provider, to spend an hour or more on a hotline when you have a job to do presents a particular challenge. And then also I want to bring up this this sort of notion around trust, both in terms of the trust that a mandated reporter, given their role, may have with a child or a family, and the potential consequence of that trust being broken by making a report, particularly in instances where you're not exactly sure whether this is a thing that should be reported, because you just don't maybe know enough. And ask, I think, I'm gonna pass it to you, Adriana, and then Jessica, and get just sort of your thoughts and reflections on your own experience about what you've seen in terms of, thinking about the actual consequences for individuals when they are grappling with and maybe taking a little bit more time to do some due diligence and not just make a report when they have an inkling that something might be going on with a child or family. I'll start with you, Adriana.
So yeah, there's kind of a lot that goes into the question. I think it is with good intentions that a mandatory reporter might, take a little bit more time or have some hesitancy to make a report. What the caseworkers see from my lens, and even in the process of, perhaps initiating a dependency and neglect action, there can often be times that the opportunity for early intervention is missed. There's this window where there might be services or, there can be supports put in place, but the hesitancy can sometimes cause the department to get into the investigation way too late. And so we are now at a critical level in which, severe things need to happen kind of quickly. And so, I know that I spoke earlier to kind of shifting that burden. I do wildly understand how the tension of when you do develop a trust with this family, that there's just this, it's hard. It's hard to pick up the phone and make that call against a family, knowing that some of the consequences of that can be severe. But from my lens, what we can experience sometimes is, it might be a little too late, or we might be in too deep if there's not, if there's some delay in getting those reports to the department.
Awesome, thank you. Jessica?
Yeah, certainly from like reviewing cases where there's a concern of a failure to report, I think I tend to categorize as like, okay, yeah, I mean, it's probably not going to be a red flag if we get a report to DHS the day after a teacher learns about something because they had the rest of the schedule and they wanted to talk to the kid and they wanted to set the kid up with a counselor and then make the report to be ready for that. I'm not going to see that as like a failure to report case. And again, I think that's because we have this wide discretion with immediately and discretion as DAs to apply the reality to the case and look at circumstances. If it's something like that, we kind of separate, was there good cause for that decision, if it even got flagged to me? The other side of it, right, is kind of what was mentioned too by somebody in the comments earlier, but I totally agree with, where I get concerned with immediacy and pausing is when, not because, logically good cause reasons come into play, but when emotions come into play. And maybe it's also just, I'm a mandatory reporter and I have reported because of that duty before, and I compartmentalize and say, it's really not my job to worry about what happens afterwards. And it's not my job to worry about my own personal relationship with this person. I had a child report to me after we developed a, I wouldn't say relationship, but acquaintance, when I presented to their school about my work. And they were very clearly showing me some kind of red flags, and then ultimately disclosed to me, and then hated me when I said, I'm so sorry, but I've got to call other people about this. And we walked through it. So I've been in that position. I've also reported on a parent, not on a parent, but on a victim in a current prosecution where the child victim was a runaway. And so reported that and had to explain to the parent that I was going to have to report that. And then I got subpoenaed in my own prosecution as a witness. Right. And so I'm also like giving it, I want to give that lens to it, in that there's one thing when there's some good cause there. It's another thing when emotions come into play, or the other most common thing I see and I worry about is like we said, a lack of training. Oh, it's just a he said, she said, so I don't have reasonable cause. And I'm like, well, you probably don't know that, not your own fault, but might not know about the intricacies of sexual abuse and how it looks and how victims react to it. And so I have more concern with a failure to report when it's because of those issues. And then certainly, of course, if it's to protect an institution. And unfortunately, those are the ones I think we see in the news. The other thing I'll note too, in terms of the personal responsibility piece, is that, and I'm hoping to give a totally different perspective here. If a child does disclose sexual abuse or discloses enough information that would cause those kind of red flags to be going off in a person who's a mandatory reporter, they've chosen that person for a reason. And it's a thought process that they go through. And so I also think it's helpful for them to have the personal responsibility to report and carry on that piece. So I'll just try to give that perspective from the child victims. I also want to note that I don't know, I'm interested in learning more about other people's experiences, but when I've called the hotline, it's taken me about 10 minutes. And so I don't know, I'm interested to learn more about, the barriers that exist in terms of taking up time.
Thank you for that. You did note in your well, I highlighted it for my own mental purposes about you just made about disclosing, sort of choosing to disclose to a person for a reason, and how that response is handled being really important. And one of the things that like, kind of, really throughout your responses and even in your presentation today that was really apparent to me is the distinction between failure to support child abuse or neglect in those instances that rise to or are likely to rise to a criminal prosecution versus cases in which we are talking about child abuse or neglect that might, I don't want to say only like minimizing, but that would be most appropriate. They're not criminal in nature, but that are involve the child welfare agency only. And so I just would love to get the thoughts of each of you around, whether that could be a way of kind of distinguishing cases that might be appropriate for mandatory reporting, where there are clearer like criminal parameters for cases versus those that need a lesser kind of, arguably lesser kind of intervention from a child abuse agency or a community provider.
Yeah, Doris, I can
I'll start
go.
with you, Stephanie.
Yeah, I'll go ahead and start. I think that we've aside from the law, right? The law never exists in a vacuum. It evolves from a culture and then it develops its own culture. And that's what's happened, in my opinion, with mandated reporting. And what I mean by that is this. First, the fact that we don't have a definition around what it means to immediately report, right? If we had a definition, right, one could actually train or talk about the notion of, hey, we have more time on this, right? There's no rush to judgment. And if you look in the document that we've provided, a couple or three different states, right? Some report in 24 hours, some 36, some 72. But what I'm saying is that you have to almost create a culture within that law, right? And so if you gave people more time to look at it, you might have a different, less fear-based even approach to it, right? So you might be like, think on this. This is important to think about. And so I'd point to that as just one example. The second big example, and again, I was chair of Governor Hickenlooper's public awareness campaign for the child abuse hotline. Kathy Wells was on that team with me. A few of us here are. And, at the time, we took a very paternalistic attitude about what citizens know and what they don't know. What could they possibly know that the professionals, right, do? How could they even begin to inform the professionals? And so that's when you came up with the tagline is, you pick up the phone, we'll make the call. That was $1 million campaign. And it went on for a couple of years. And I think we still have some miscellaneous billboards out there. But my only point is the law is so important and the words in it are important, but it also needs to reflect the culture of what we're trying to create, right? And in this instance, what I think I've heard consistently from the group is trying to really narrow that door, right? But when you have a public relations campaign that says, just pick up the phone, we got it, you're not going to narrow your front door. If you don't put definitions into the law, like what does immediate mean, right? You're not going to narrow that front door. So I just think that it's that confluence between law and policy by people with lived experience. That means everybody on this phone and beyond. And that's I think the challenge we face is you got to change your messaging, because if you don't change the words in the law, and you will change nothing. You really won't.
Yeah, thank you for that. Yeah, I mean, that was the steady drumbeat about if you suspect, if you have an inkling, make the call. Don't hesitate, make the call. Adriana, you said something in your survey that I thought was really powerful. As I know I had originally said I wanted to hear from all of you on my last question, but Stephanie said something that I thought was really important that reflects back on something you said in your survey. You said that we must reject any system where compliance is only motivated out of fear. And so this idea of, sort of like sparking that fear of not reporting, even if you have an inkling, has both the consequence of, widening the front door, but also reducing, any kind of thought process, or removing any kind of, thought process, so that people are making kind of informed decisions about reporting. And so I want you to just expound on that statement you made, and whether there are any specific recommendations that you have in addition to what Stephanie shared.
Thanks. Yes, and I think I kind of touched on this a little earlier. First, the data reflects, to even Jessica's point, that a failure to make a report likely stems from either a lack of knowledge, a lack of confidence, a lack of certainty. So we need to, instead of having this fear-based model, really embrace the notion that these mandatory reporters are placed in these levels of professions for a specific reason. That comes, they're not criminals. They act in good faith. They, most of them have licenses that teach them as much in their own professions. So we need to stop looking at this as a willful failure instead of a, I don't know what to do next. To Stephanie's point, I also think, we do need to match it with the culture. The culture is that most people, at least in my opinion, reach out because they have either valid concerns or they simply just want this family to get help. The fear comes from, oh, I can't connect them to resources or to help because the department is going to immediately intervene. That's going to have such negative consequences. So we really do need to focus on making the culture, a safe space for informal reporting. Can there not be different level of reporting of, hey, I've got to make this immediate call because I know for a fact that this child has just disclosed sexual abuse. That is immediate, that is critical, that requires, a giant response versus, I'm not quite sure, is there another person? Is there another hotline? Is there another type of reach out that I can have to say, here's what I know, but I don't know for certain. I have these suspicions because of X. I haven't received a full disclosure from the child, but I'm concerned based upon this and my working profession with them that they might be struggling with in this area. Can we not connect different levels of, again, to the point of defining immediacy? Can there not be things like different levels of what requires reporting? Can there not be different, even in my profession, if I have a legal or an ethical question, there is a hotline that I can call. There's, the Bar Association, to where I can, without facing any consequences, say, I have this concern, what do I do next? And there's a team that's appointed to kind of help give some general guidance to me. Why is there not that when we're so concerned about the safety of these children? Why can't there be a team that says, sounds like this person just needs to be connected to services, what's available in the local area, versus, oh, now this is a hotline call to the department and they're now involved in things are much more dramatic than even I'm confident in making it be.
Thank you. And I just have a follow-up question. So based on what you said and what you shared in your survey as well, part of that challenge in making reports when you're not quite sure and you think that the family needs some supports is about perception, and potentially the heaviness of the intervention for kids and families. Do you have any thoughts on ways in which that this group by recommendation or the state could shift that perception and or use another mechanism to better connect families with services and supports?
Yeah, I think there was another member of this panel that spoke previously about their kind of connections to resources and using different, now of course I forgot the term that was used.
The word lines?
Yes, thank you. That's not out here in Delta County, so that's not something I'm familiar with, but when I heard it, I was just like, yes, that sounds amazing. And so I would advocate for that as well. And then I lost it. What was the second part of your question?
Just ways to connect families with more services and supports. And then the other part is shifting the perception.
Oh, thank you. Yes. You know, shifting the perception, I think, is honestly going to be the hardest piece. Yeah, because to Stephanie's point, you know, the law is just words on paper. And so we want to push it. We want to make a strong push, but it's the cultural buy-in. It's for a long time, I think that there's just been this pervasive amount of fear. And so how we eradicate that, I honestly don't know. But I know that it's going to be heavy. And I know that that's going to require a lot to get us to viewing this process in general as a more positive approach or experience.
Thank you. I'm going to come to you, Jessica. One of the things that you acknowledged was in your survey response was there were a couple of things. One was the lack of understanding of neglect and child abuse that we've already talked about, but also the impact of bias. And you know, the way that, and we've talked about the data as it relates to disproportionality and interventions. What, if any, recommendations would you make to how the current system is structured to both increase understanding of what neglect and child abuse actually is, and ways to reduce bias on the impact of bias on how reports get made?
Yeah, thank you. You know, to me, it also, of course, it comes down to training. And I think it's interesting because when we look at the legislative intent of who are considered mandatory reporters, right? They're chosen because of their specific experience, their training, or their role with children. I believe. I think those are kind of the main reasons why they're chosen. It doesn't necessarily mean that they're trained on implicit bias. It doesn't mean that they're trained on gender and racial bias or poverty bias. It doesn't mean that they're trained on the intricacies of child sexual abuse or how to respond to child sexual abuse reports without damaging the child, causing more trauma, or damaging a future investigation by asking questions or inserting terms. That's something as prosecutors we worry a lot about with mandatory reporters, is maybe they're not trained on, you know, making sure that you're not accidentally inserting terms. Even with police officers, I've seen them take mandatory reports from a child and the child goes, well, they touched me inappropriately. Where on your vagina? And we were like, what? No, she never said anything about that. That just, you know, destroyed something. But to me, I think it's tough, right? I say, oh, let's require training. But in reality, right, when we're talking about the huge breadth of reporters and how many industries and how many careers and professionals are put into that, I have concern about the, you know, the actual likelihood of that. You know, it's easy for me to say as a lawyer because like Adriana, we're like, oh, we have these supports. Because of our ethical duties, we have those call-ins. And we have required trainings on DEI or EDI, and we have those, you know, requirements. And yet I'm still training, you know, prosecutors and law enforcement on the intricacies of unlawful sexual behavior and what it actually is. So I don't know that that's enough, right? I think that there has to be, I don't know, I guess I'll leave it with that because I don't have all the answers, but I think that that's what this group can definitely have great input in and suggestions about. I also want to really quickly hit on your previous question and comment about, you know, is there potential to distinguish crimes and that level of failure to report versus like child welfare or DHS? I get a little concerned about that because some of what Stephanie was talking about earlier, and our concerns that we have generally with the way this law is what obligation of knowledge are we putting on mandatory reporters? And are we going to increase that by saying, okay, now you have to know if it fits into a crime? And that's a whole other, you know, hundreds of statutes. So I think that's why it has the, you know, it references the definition that it does, and it's all treated the same because it's always a safety issue, right? Whereas like if it is going to meet the level of a crime, that's a whole different standard of proof, a standard of evidence, and way different than if DHS needs to intervene and provide support, or if a child's in an injurious environment that they need to be taken out of. So I hesitate to split between those. I think part of that is just because of my perspective only comes from the criminal side, whereas Adriana obviously has more of the perspective from the child welfare and DHS involvement side.
Awesome, thank you. Stephanie?
Yeah, I just wanted to add to the conversation, as somebody who has been studying this law now for, frankly, exposed to it for probably 30 years, but studied it hard for the last 4 to 5. I just give this to the group to consider because I've talked to people, experts literally from around the country. And one of the things that has routinely been said to me is, be careful in just tweaking systems, right? In other words, just sort of modifying the law. And people have even said to me, why aren't you abolishing mandated reporting? People call the police when they see their neighbor being broken into, right? People call the police when there's a car accident, right? And I am not here to support that view one way or the other, but it is just something I think that's important for us to entertain, only because there is a lot of discussion. There are a lot of scholarly articles that are being written about this. And I think that those are just always important for us, right? To make sure that we're not sort of in the echo chamber, but that we're considering, a multitude of different perspectives by people who are very learned about the topic. And so I just throw that out there, maybe to be provocative, I don't know, but I think it's important to consider that. And I also just think that as we begin to break into subgroups, that is research that, our group will be bringing in, just so that we feel as a group, as a team, right, that we really are understanding the multitude of perspectives and frankly options, right, that might be out there. So I just wanted to share some of those responses.
Yeah, I think that is an important question, and it is provocative to sort of pose this idea of whether mandatory reporting laws are even necessary, or whether it's necessary in Colorado for reports to get made about child safety. And I think that that's a question that this group could and should be grappling with. With that, I'd love to turn it over or open the floor for members of the task force to ask our amazing, very informative, generous with their time and thoughts panelists any questions that you're ruminating on, both in thinking about the data and themes that Jessica and Adriana shared from their perspective, and also the additional thoughts and ideation that the three have done in their work in this space. So I'll open the floor for questions from the group. Gina, I see your hand up.
Yeah, and I appreciate all that you all shared, and I don't know that I necessarily have a question. I guess I just kind of want to continue to make sure it doesn't get kind of, not that it is, but just keep it to the forefront around again, like the impacts of good versus bad players in terms of the professionals that we're talking about here, because especially in the legal aspect, I worry that this is creating like this culture of like, who wants to even become any of these professionals. And we understand that these folks are so necessary to the functions of these services and departments that we need in our communities, and good people, right? Good folks who want to be in the work, being faced with all of these like different rules and ambiguity, like who wants to even go into this profession and like be facing potential penalties and distrust in the community, like right off by even coming from this system that, is deeply entrenched in this, all of the things, right? The harm and the distrust. We need good people. We need good teachers. We need good administrators, and we need good social workers and things like that. But I also worry that like this ambiguity also can attract folks who, aren't I don't want to say bad because I don't really like any of that, but like who may seek these positions to kind of police some of our families more than others, specifically because of maybe the communities that they come from and what kind of vulnerabilities those communities sit in when those kinds of folks are positioned, those kinds of professionals are positioned in places where they have this fear-based idea of mandatory reporting plus like this penalty aspect of it and the ambiguity again, right? And like I want to just bring this particular example forward in that we were in a Native parents committee meeting, and the principal at the high school was talking about how there needs to be a return to like our elders and grandparents being involved in the parenting of children, and that we need the grandparents back to whip these kids because that's the only way they understand how to get to work and how to get their work done and to behave and to be all the things that our kiddos, our Native kiddos should be in his school. And I was really surprised he said that out loud, but also not so, because it, again, like we have this tendency to like sub-meeting these kinds of conversations, especially with marginalized communities. And it kind of seems like, oh, we're giving this space to this particular focus. But I also feel like it also gave way to this problematic behavior where like this, not only ignorance of like the cultural aspect of it, but this way of like using this aspect of like teaching and parenting in a way that like, and with the penalty aspect of it behind it, kind of throw in these like really weird comments that I had to stop him and ask him if he was suggesting that our elders employed physical child abuse. As a teacher, you are suggesting that that's what we should be doing. And second to that, if you are saying that, are you also going to show up in our courts with our elders and testify with your licensure and all of your credentials to say that you're the one who suggested this? Are you going to be there to the defense of these elders who are going to face charges when you're the one sitting in your position of trust and authority and professionalism, right? That you're the teacher, you're the education system, and you're saying that this is what the kids need, right? And so a lot of in my work and in my experience, a lot of our families and some of our communities are historically sitting at a disadvantage when people in those positions are making remarks like this, right? And maybe there is already abuse happening in those families, and it just kind of emboldens that. And at the end of the day, we end up right back in that place where, our marginalized communities, children from those communities sit in this really weird and unsafe place due to the ambiguity. So I just, again, want us to like think about those impacts in that way, and that the ambiguity and the lack of the clarification about how this works, it really puts some of our folks, some of our communities, some of our kiddos and their families in a particularly problematic situation, especially with our school systems and things like that. And like I said, we need our educators, we need our principals, we need these administrators, but also like, I'm just so concerned that this ambiguity is allowing for, some very questionable players in those positions. Thank you.
Thank you, Gina. Thank you for making sure that we're keeping marginalized populations at the center of this conversation. And I think the other thing that I heard from you is really thinking about how we ensure that we have a workforce that is both well-equipped and well-intentioned in all of the fields that we're talking about in mandatory reporting, many of which are having significant workforce challenges. Thank you. Jessica? And then we'll come to you, Kelsey.
Yeah, thank you. I wanted to kind of go off on that comment with some thoughts too. I love Gina, and that she always sparks amazing other creative thoughts in my brain when I talk with her. The other thing I think is important, and I guess, what I deal with more as a prosecutor when there are failures to report those unlawful sexual behavior instances, right, is rape culture and people in those positions who are completely in and part of bad rape culture. And then when we add that onto, right, especially because we're not only talking about small children where it's like, oh, you know, a 5-year-old was abused. No, we're talking about people who are reporting, you know, maybe a 16-year-old is reporting abuse by another peer. And then if you take that and you take some of the rape culture and then some of the effects of and what we know, right, that people of color, people in marginalized communities, certainly Indigenous people and Native Americans are more likely to be susceptible to that abuse. And then you add in biases that say that just historically, a lot of people in those communities are also not necessarily believed when they express things like pain, when they express things like reporting crimes or harms that have been done to them. And you add all of that in and put it on a mandatory reporter who's then trying to, you know, who's a human and is grappling with all those things. And that's what scares me, right? Is that those things seep into mandatory reporters' decisions and end up, I know we focused on obviously the negative impact of over reporting, but then of course, always my concern, because especially, like I said, I know I focus so much on unlawful sexual behavior, but that's me and my role. Because it's the most underreported thing, that those come into play and allow more concern or allow more harm to come to those communities because of all those factors interplaying. So I want to thank Gina for calling that out too, because I think there's more to that. And now, you know, final note with that, we have the missing and murdered Indigenous relatives work that's being done too, to also, which I think reflects on the reality of the lack of focus on those communities when it comes to law enforcement, when it comes to helping abate harm. So thanks.
Thank you. There's a book by a woman named Ijeoma Olua called So You Want to Talk About Race, that has a quote in it that I use a lot, that says, I'm going to paraphrase it, but that systemic racism is effectively self-perpetuating. You have to actually dismantle the thing. You have to dismantle it. And so when we think about you know, coming out with recommendations, we have to actively apply an equity lens to those recommendations to ensure that they are structured in such a way that they will intentionally disrupt the ways in which bias, racism, oppression will necessarily intervene if we're not being intentional. So thank you for also just reminding me of that critical, important piece of whatever the byproduct is of this group. Thank you. Kelsey?
Yes. So I also just wanted to go kind of along with this conversation as far as just working with marginalized population. I work at Denver Health Medical Center as a licensed clinical social worker, and I've been here 6 years, and I've seen a lot of kind of staff, and it also goes off of like the amount of training that we definitely need as mandated reporters, because I see a lot of nursing staff coming to myself or social workers covering about certain concerns, and it might be cultural based, or it just is because of their a low-income family. And I've seen this a lot over the years. I've seen reports that probably shouldn't have been made when you know, it's going off of a bias. And so I just wanted to add to the conversation of just, we had been talking in the chat as well, that I do think like more training on mandatory reporting in general could be beneficial. And also just for all professionals, not just social workers, school teachers. I feel like the systems are very big as far as working in a hospital system. There's many staff, there's many medical providers, and you know, as we know, it's not cut and dry. And I think there's just a lot to navigate there. And just the other thing is that I do believe with more of this, like obviously that's the goal of being a part of this task force, is just coming from all of our different perspectives, is that we do hope for a change and better ways to make a report, as well as more beneficial reports.
Thank you, Kelsey. What other questions, thoughts, reflections do our task force members have of our panelists?
Doris, can I add one small thing that I want to make sure I cover?
No, Jessica.
And I want to open up something because I really want to hear this group's discussion on it. It was something that I discussed, like I was thinking of before presentation. And okay, the one other thing I want to make sure too is that I want from the criminal justice aspect, I want people to know that sealing is available for failure to report cases, whether it's up to the judge, but I just want to kind of point that out as well. It's just another layer to put in there that I just didn't want to forget about. And Kevin can probably talk more about kind of how sealing actually works and all of that, but it is.
For the non-legal people, Jessica, can you say what that means?
Oh, yeah. So say if somebody is charged or even convicted, there are certain crimes that then they can ask the court to seal, or I should say most crimes are sealable. I didn't deep dive into the sealing statutes before this, but what sealing means is that then if it's granted, only law enforcement can really see, and district attorneys can see that history, but it basically, they're not allowed to comment on the fact that it is that somebody was ever charged or convicted with that crime. If they're given questions about it, they just have to say, I don't have any record of that. And they don't have to, the person no longer has to like report it on, future questions and applications or leases or job applications or things like that. Kevin can probably expand more on the defense side because I just get the requests for it, but.
Yeah, I mean, I think that one actual question that I have would be, and I know that Zane isn't representing Dora at all, but whether the sealing actually affects the ability to maintain your license. I know that with Dora, they report and they have publicly available information. If you go to their website, you can look up anybody to see if there's ever been any stipulations or findings against them. And if you have had this history, does Dora sort of effectively unseal it by posting that on their website too? Just a question. And I really do appreciate the option to seal, I think is a good one.
Yeah, and that's something that we haven't talked about before. So I think generally when we think about sealed records, we think about them in the context of minors. And so if they're, when we think about, education, educating mandatory reporters as a recommendation from this group, sort of like that education piece on what could be sealing of any findings so that there aren't any subsequent long-term consequences, I think is important information for this group to know.
Mm-hmm. The other little issue that actually I think Gina brought up too, in terms of the consideration when we are considering some of the directives regarding the scope of the duty to report for mandatory reporters, and like we were talking about in the chat too with the Court of Appeals finding that it's all the time. There is no ending to it in the way that the law is written. When we consider potential recommendations to legislative changes for that statute, and I know in Stephanie and the CPO's briefing, they did some great research on other states that do place, restrictive words like in the person's official capacity, things like that. I think that's a super important conversation. And I also think it's important to break down the different types of mandatory reporters that exist, right? When law enforcement or prosecutors, we're law enforcement, so we're on all the time. It doesn't matter whether we're, on duty or not, but should that same, and personally, I don't really speak completely for CDAC in this because I haven't gotten like all of our opinions on it. I think that's the right thing because we're law enforcement and that's a very special role that we've taken on. But I think it's totally different to put that kind of burden on teachers, on I'm trying to think of other professionals that are in there, but I think there's like ophthalmologists and people that aren't really expected or weren't placed into that role to be on all the time. And so I put that out to the group because I'm really interested in hearing some of the different people in this meeting and what they think about the different tiers, whether there should be on duty, on capacity, whether it should extend to longer, bigger scopes for certain professions. What do people think about that?
Yeah, I think you're posing those meaty questions that that this group will have to grapple with, right? I think the question that Stephanie posed earlier about the extent to which a mandatory reporting system is even needed, and then also these questions about like if yes, then do all of the classes of individuals that are required to report under the mandatory reporting statute make sense? Or might there be different kinds of groupings of professionals based on their particular role and interaction with kids and families? So all of these very meaty questions for this group to grapple with. What other questions, comments, thoughts, reflections do we have from our task force members? Trace informs me that we don't yet have anyone who raised their hand for public comment. So we have about 9 more minutes or so for questions or comments. What'd you say, Trace?
Or we do have one person, so that's why.
Oh, gotcha. Okay.
Yeah,
okay.
yeah.
I misread your chat. Sorry. I'm like scanning my little Hollywood Squares boxes and looking at the thinking faces. So I have a question for the group. So we have talked about, Stephanie, it looked like you were going for your mute button, but we've talked about this notion of there needing to be an opportunity for reporters to report outside of the child welfare agency concerns where a family, like we think the family needs resources, but also a need to ensure that there is collaboration with child welfare and community-based providers who can potentially meet the needs of kids and families outside of the system. I'd like to hear from the three of you, and we'll start with you, Stephanie, about what that collaboration could look like, or what you think might be some of the key elements of that collaboration and coordination.
Yeah, that is the $1 million question, Doris. Intuitively, what I think I'm always trying to aim for is what do we already have in place and what can we build on? And so I really appreciated the conversation this group had, I don't know, a couple meetings ago about the use of our family resource centers, right? And redesigning, repurposing, supplementing, right? Better funding, whatever the word is, to try to accomplish the notion of a warm line, a place where people can get resources. I think my biggest concern in terms of trying to partner with community entities, I don't think we have enough resources. and so I think my fear is, and I'll just take the behavioral health system, as all of you know and read, we don't have behavioral health resources for most anyone. And if you're working within child welfare, we really lack appropriate resources for our youth in care and their families. And so my only concern is, right, feeling good about setting a shell up, going, yay, for us, we set up a thing. And then we're like, but the thing can't really operate because in the community, we haven't done an appropriate survey. We haven't worked with the community to see what their needs are first. And secondly, how we would help accomplish meeting those needs, right? And so that, I think that's just my biggest fear, is this takes time and you have to work with communities, right? It can't be a situation where from on top, the state goes, da-da, here's 5 warm lines for your consideration. And so I think that my biggest thought, I've only raised more concerns. I appreciate that, Doris. just as we get to solutions, I think it's just important to look carefully at how those solutions are crafted and with whom we create the solutions. You know, Crystal and I have had some robust conversations. We're looking at, I think, at about half a dozen different pilot sites throughout the country that are starting to entertain this notion of warm lines or support lines. And I think that that is going to be critically important if this group decides to go in that direction, to go, how did you do it? Right? What can we learn? And so on. So I guess, I'm sorry, Doris, I don't have solutions, but I do have a lot of thoughts about process and how to do it so it matters.
Yeah, I mean, I think that is, I didn't expect you to really have solutions. I knew that you had some thoughts and ideas, and likely that you had more questions, but I think a couple of points that I just want to you know, kind of resurface or restate is, one, that this work can't be done in a vacuum. That, you know, we know that there is other work that's happening both on the ground and by way of study committee and collaboratives. And so having a sense of what that work looks like and how it's shaping up, I think is important, and building off of those. And also looking at, you know, other places that are grappling with these same kinds of questions, and, you know, using that as a resource to both learn from and with to inform this group. And so I think that that's going to provide an opportunity as we, in the start of the year, move to like really grappling with some of these specific tasks or charges of this task force. We can delve more deeply into that. Adriana or Jessica?
I would just like to selfishly add on top of Stephanie's point and really stress and carry it even further. I am a huge proponent of resources. I am a huge proponent of supporting families with services. Out here in Delta County, there are 4 agencies that offer therapeutic services. And so while I would never say no, I want this group to remain ever mindful that the intention and the goal is always to wrap families around resources. And if that's our recommendation, I think that would be great, but let's make sure that it is actually met. So this new hotline, this new culture that we are trying to create, to Stephanie's point, is not just this shell, or is not just this empty promise of, hey, you know, we're going to connect you to services that literally do not exist or have availability out in some of these communities and regions. To more of the point as well, though, and I think it's wild to open the discussion of whether mandatory reporters are needed. I am so looking forward to diving in on that. What I will say kind of to that piece and to Doris' question overall, though, I view the working relationship between mandatory reporters and caseworkers in their investigation, it's critical. It really is this symbiotic relationship. And so I know that there is, or can be, this negative and drastic view of the department's intervention. At the same time, I would also challenge this group to be mindful at this moment. And of course, we can always advocate for a change in this, but the department and the caseworker is not only the person that has the training to do investigations, but they are the system in which puts all the pieces together. Meaning in an investigation, the mandatory reporter might say, well, I have this limited knowledge. That caseworker takes it back to the other people that they have interviewed or the other information they've gained in their investigation to put together this whole picture to hopefully the benefit of the family, to, you know, either connect them to resources or make the determination that there is abuse or neglect going on. And so I am, again, well aware of the conversations we've had about how that has had a negative impact on minorities and, you know, different parts of our community. But at the same time, that system needs to be maintained, that symbiotic relationship in the process of reporting. So that will just be my last shameless plug.
Thank you, Jessica.
Yeah, you know, I'll say for me, it's hard for me to consider living in a world without mandatory reporting. Like I said, primarily my heart goes to the unfortunate like rape culture that we live in and child sexual abuse culture that we live in, and that is a barrier and a prevention source of that, and that to me it's the best one, but I think that that's not without saying that there are issues with it. In terms of your question too, and like collaboration and how we could connect between different perspectives and parties that play roles in these type of cases. You know, my primary thing, and maybe it's clear because of my role for prosecutors, is how do we support mandatory reporters? We've placed them in a position of trust and of authority in the community. We've selected them and said, you are burdened with this duty and you are burdened with all of this. And then are we really doing a good job in actually providing them the support that allows them to fulfill those burdens? You know, I think about that with attorneys and with law enforcement, and I can't say enough how much I like the idea that Adriana pointed out of like, how do those groups in positions of power and responsibility and safety, how are they given support? And are there any ways we can look to those groups and mirror or copy some of the same things and provide that for mandatory reporters so that they can have a soft ability to ask questions if they have concerns, so that they can find other resources and go, well, you know, is there a way I can just connect with resources instead of, you know, involving DHS? I think that's an amazing opportunity that we have, in addition to looking to other states, is looking to those other groups that we've placed with that same burden and trying to find out how to support mandatory reporters so that they never land on my desk ever. So that's my thought.
And thank you. Roxanne, I saw that you had your hand up, you put it down, and then you put something in the chat. Do you want to just voice over into the room your thought process?
Yeah, I want to say how much I appreciate the awareness that we can't like take away something harmful, but then not have a system to support it. So like it's both and. And I also appreciate the awareness that we have to live in the real moment, like, right? So even though that's our goal, we have to live in the truth. And I guess I wanted to push back a little on the idea that in the meantime response should be more people into the system or better connections between the current system, like trusting the system more. I feel like that's a little bit what I'm hearing, that like, well, if we had better trust or better training, we could have a better relationship between mandatory reporters and systems. And I really want to push back that doesn't feel safe. I think the right answer needs to be that advocates who are professionals, like teachers, like doctors, you know, people who have this experience, we should actually trust that we should give them more options to recognize that when the system is harmful, there are other places that they can go. And that should be our in-between answer, in my opinion, not that we like shore up a system that's harmful now, or that we put more people into it and hope that the system does a better job, because we know that the perception is not our problem. The system is harming people. So we can't, you know, changing the perception, rebranding, those are all things that feel really dangerous to me. I think we need to be honest about what the system is doing. And then how do we actually both change it over time and make it safer in the meantime? But that's what I would advocate for.
Thank you. Other thoughts, questions, reflections from the task force?
See Jennifer's hand up. Jennifer, you want to go ahead?
Thank you. Yeah, I wanted to chime in because I just want to speak to what Jessica was saying about child sexual abuse and sexual assault. And it would be interesting to look at data if we had it, and Casey Family seems to have some amazing data on the percentage of reports that really fall into that category, because I think those are really serious, really severe, really scary situations, and I don't want to disregard that we want to respond to that. But I don't think those are the everyday reports that are coming into the hotline on a regular basis. You know, the reports that my team are making are, you know, abusive parent has been, you know, endangering the child, and the protective parent has left the situation, and we still have an obligation to make that report because of the way the statute reads, even though we know the child is safe and that the department responding, if they do, creates more harm and more danger. So I just want to kind of tease apart that this isn't an all or nothing conversation, which I think was Rashan's point as well, that, you know, maybe there are different reporting options. Maybe you report if there is a certain type of allegation. I don't know. I don't know that I even agree with that idea, but just thinking out loud. And I just wanted to name that, you know, I think it can be really easy to get caught up in really scary situations and get worried about, well, what if no one reports that, when those are really the minority of reports.
Yeah, thank you for bringing us back to that. You know, the data showed us that Casey shared with us, and you know, nationally, this is also true. The vast majority of kids and families that get reported to child abuse, to the child welfare agency, is for neglect, often conflated with poverty. And so when we think about the system, the populations, the needs and issues that are being reported on, there is a very small percentage of those that are really about severe neglect, abuse, or sexual abuse. So I think that was an important reminder to us to kind of keep that as part of our conversation. Thank you all just for joining us in conversation today, for your work in putting together, Jessica, Adriana, some additional presentation, for Stephanie, and really for all of you for your ongoing commitment to this work, both inside this panel as well as in the work that you do every single day. It was a pleasure sharing space with all of you and hearing some more insights. With that, I'm going to turn it back to you, Trace.
Thanks, Doris, and thanks, everyone. We've got 3 minutes left. I'm going to run through a couple of business items after I go through public comment. We have one public comment, and I'm removing spotlights. Sorry for the delay. There we go. That has been requested that I just read a statement. So I wanted to read that statement to you all. I've also gotten their email in case anyone would like to follow up directly, but just more comfortable reading the statement. So this is from Krista Christensen, and she wants to say that she's speaking from a lived experience perspective. An inexperienced school social worker had very little information to work with to make a report because her child made one fictional statement to bring attention to himself. As a result, the social worker made up her own story to report, which really opened the school up to litigation because the school acted upon the false information from the child. It also opened the social worker up to being reported to DORA. I share this to echo earlier statements in the chat about clarifying and training what mandated reporting is to mandated reporters. In addition, my question is, how do we bridge the gap between how police see their role and how DCFS sees their roles? I believe DCFS, if anyone can correct me, are we referencing CDHS? Okay. Because the school called both DCFS and police, we experienced DCFS saying there was literally no evidence of abuse, while the police issued an unfounded citation. It was clear to us that the school put themselves at risk by calling police, whereas things wouldn't have escalated if the school had only called DCFS. Agencies also need to know who they can trust with their reports, not to create bigger issues for them. And yes, there was litigation and money involved for the school district because of how our situation was mishandled. So I want to say thank you to Krista for sharing that statement with the task force. And again, I have Krista's information should anyone want to follow up. And Stephanie, I'll share that with your team as well. All right, I have received no other requests for public comments. I'm just going to end with a couple of quick announcements or just reminders. So one, a reminder from Jordan around the December meeting being canceled due to us spending that time on that interim report. So there will be opportunities to give feedback there, very specifically around how we've captured the interim report. So be on the lookout for that. In addition, working group opportunities for 2024 will be coming up. we'll see how folks self-select in, but there also might be some voluntold opportunities there, not gonna lie. And then the last piece is that we're gonna move again to monthly meetings in 2024, as well as we've done in 2023. So you'll see a lot of things blowing up in your inbox. One, the December meeting cancellation, but two, the additional meetings being added for the rest of 2024. With that, Stephanie, if there's not anything else to cover, I want to say appreciate all of you. This was a lot, a massive discussion. Really appreciate all the panelists and Jessica and Adriana also for your presentation. I know all the work that went into that. So deep appreciation for each of you. Reach out with any questions. Otherwise, we'll be in touch via email soon. Thank you so much.